Boa tarde a todos. É uma honra participar de mais uma edição desse prestigiado Seminário Internacional do IBRAC. Bom, o evento está cada vez mais internacional, com diversos palestrantes de outras jurisdições, inclusive esse painel. O que confirma aí a relevância da comunidade antitruste brasileira, né, na esfera internacional e o protagonismo aí que vem desempenhando nessa área. Gostaria de agradecer o IBRAC, o presidente Márcio Bueno, a diretora de concorrência Leonor Cordovil, pela oportunidade de apresentar esse painel. Tenho aqui colegas especialistas em 4 jurisdições, Brasil, China, Europa, Estados Unidos. E o motivo pelo qual nós escolhemos essas jurisdições Vou pegar aqui a apresentação. Aqui. Bom, nós temos mais de 120 jurisdições com legislação antitruste. Esse número vem aí aumentando, como mostra aí o gráfico. Em parte é um reconhecimento, né, dos benefícios do que a política de concorrência contribui aí para o desenvolvimento econômico, para o bem-estar dos consumidores, das economias nacionais. E então, essas 4 jurisdições escolhidas, né, nós temos 2 aí mais tradicionais, a Europa e os Estados Unidos. Os Estados Unidos tem a legislação concorrencial há mais de 100 anos, o Sherman Act, o Clayton Act, e desde 1976, com o Hart-Scott-Rodino Act, tem aí uma legislação controle de concentrações prévio, né? A Europa também tem uma reconhecida tradição, uma aplicação rigorosa da lei. O EU Merger Regulation, né, que é de 89, ele é efetivo desde 2004. O Brasil introduziu aí um controle de concentrações em 94, mas até então o regime era posterior, né, não era prévio, e passou a ser prévio a partir da lei que entrou em vigor em 2012. Né? Então, o Brasil se destaca aí, recentemente, a Global Competition Review, mais uma vez, consagrou o Brasil aí com uma agência 4 estrelas, está aí entre as 10 mais eficientes, né, do mundo. E a China também, é bem relevante falar sobre a China, que esse ano a lei antimonopólio comemora 10 anos, teve uma mudança estrutural na autoridade importante, e a China é o maior parceiro comercial do Brasil, também o maior parceiro comercial de mais de 120 países, então ela precisa estar aí no nosso radar, né? Em termos aí de concentrações globais, nós temos percebido aí que um aumento de operações que são apresentadas em 3 a 5 jurisdições, né? Então, temos aí 20% de operações realizadas por empresas multinacionais, apresentadas, notificadas em pelo menos 3 a 5 jurisdições. E dentro desse número, provavelmente, essas jurisdições envolvidas serão Europa, Estados Unidos e muitas vezes China e também Brasil. Bom, quando essas operações globais são simples, né, e não envolvem aí problemas concorrenciais, A questão maior aí de desafio é o cronograma. Em alguns casos, a operação poderá ser analisada rapidamente em procedimentos sumários, em outras jurisdições, talvez em procedimentos mais demorados, aí, em ordinários, mas se a operação não envolve aí um remédio, isso não vai ser um problema, né? A questão mais delicada, o principal ponto de atenção é quando essa operação necessita aí de algum remédio. Então, qual vai ser o desenho desse remédio, qual vai ser o critério aí para escolher os compradores, qual é a viabilidade aí de se desinvestir um negócio em outro país, enfim, a questão de trustees também, que as autoridades têm sinalizado aí pela necessidade de se apontar em um único trustee. E quando a gente pensa, né, nos desafios nessas operações globais, muitas vezes, né, o que isso pode acarretar, né, uns cronogramas desencontrados, algumas jurisdições recebem a notificação da operação num determinado momento e outras jurisdições recebem muito mais tarde. Às vezes quando pode até ser em situações que a decisão já foi inclusive proferida por uma jurisdição. As autoridades utilizam aí diferentes padrões de análises. Existe aí um risco, né, de decisões conflitantes, decisões inconsistentes. Isso gera um custo elevado para as empresas. Enfim, tem uma estimativa da Price de que uma operação pode custar mais aí de 3 milhões de euros e levar aí por volta de 7 meses em taxas de submissão e, enfim, despesas aí pelas empresas com consultores, advogados, etc. Então, como ponto de partida que eu coloco aqui, seria comum aí, né, a todas as jurisdições, primeiro entender as diferentes jurisdições e os critérios de notificação. Isso é cada vez mais importante, já é uma realidade aqui no Brasil. Então, nós, quando da prática privada, quando somos abordados pelos nossos clientes, temos que checar aí em quais jurisdições os nossos clientes atuam, quais são os faturamentos, e embora nós, assim, no caso aqui de advogados brasileiros, vamos falar sobre a jurisdição brasileira, enfim, é importante sinalizar para os nossos clientes que a operação dele pode ter que ser aprovada em outras jurisdições, para que a gente coordene aí, entre em contato com outros advogados, para que eles possam confirmar se há aí essa necessidade de submeter a operação em outras jurisdições. Então, identificar também possíveis problemas concorrenciais logo no início, fazer uma análise de risco, a expectativa dos prazos, né, para obtenção das aprovações. Na palestra de ontem, o superintendente adjunto, o Kenneth Menezes, mencionou que as empresas precisam ter no radar o Brasil, o risco regulatório Brasil, né? Isso, enfim, em uma operação global, com efeitos no Brasil, com empresas que tenham atuação aqui no Brasil, isso precisa ser identificado, precisa ser mapeado logo no começo. Uma operação global vai demandar também o preenchimento de diferentes formulários, a coleta aí de inúmeras informações. Essa atividade também precisa ser coordenada para que não seja aí tão prejudicial ao dia a dia da atividade das empresas, né? E, enfim, e também recomenda-se a assinatura de waivers de confidencialidade para que as autoridades possam trocar informações, elas precisam, né, trocar informações para que também seja evitado aí algo que seria muito indesejável, que é uma decisão conflitante, né? Então, para que elas possam discutir a operação, elas precisam ter esse waiver aí da confidencialidade. Então, a pergunta que eu fiz para os nossos 4 palestrantes é: qual é o estado da arte em termos aí de análise de concentrações globais nessas 4 jurisdições? Eles vão discutir em cada uma delas quais os temas principais, os assuntos que estão chamando atenção, que merecem ser destacados. Então, vamos falar de gun jumping, vamos falar de cooperação internacional, e, enfim, estamos aí depois abertos aí para discussão com todos vocês. Eu passo a palavra para Cunzhen Huang, consultora especialista em direito chinês, do escritório Cleary Gottlieb, ela é baseada em Washington, D.C. Obrigada.
So Joyce, should I also do the presentation? Thank you, Joyce, and thank you, everyone. I'm very delighted to be invited to the panel to talk about one of the big 4 antitrust jurisdictions in merger control review regime, China. So China merger control review regime actually was established back to 2003. At that time, still under the Chinese foreign investment rules. However, the regime was not actively enforced until 2008, when the anti-monopoly law of China was officially effective. So in the past 10 years of enforcement, China has really shown to the global business community its muscle. So it is never shy away from spending much longer time than other jurisdictions to approve a global transaction, being the Chinese bottleneck, and asking for a greater scope of remedies compared to the global remedy package, considering Chinese stakeholders' concerns, even if they are non-merger specific or not antitrust related, or sometimes even imposing prohibition on the transactions. So far, there have been more than 2,000 cases in the past 10 years that have been reviewed and proved by the Chinese Antitrust Authority. And there were 2 prohibitions and 38 conditional approvals. So the merger control review was always taken care of by the Chinese Ministry of Commerce. The sole jurisdiction was with MOFCOM back to that time. Nowadays, China is also doing integration of Chinese competition enforcement agencies, like what Brazil did back to 5 to 6 years ago. So we had NDRC, who used to be responsible for price-related behavior, as AIC, who used to be responsible for non-price related behavior, and MOFCOM to be integrated into one single agency, State Administration for Market Regulation, called SMR. So right now, all the cases have to be notified to SMR, although the case team on merger review is still largely the former MOFCOM officials. But sometimes if you got bad luck, you would meet with the former NDRC or SSA officials who had no merger control review experience in the past, but put on the merger review force right now. So then you would have to put extra effort to get your case through. So in terms of substantive review, China actually has been paying more and more attention to conglomerate effect as one type of theory of harm, especially with cases there are no horizontal or vertical issues at all, so that the clients normally would expect you to get a very clear clearance for them. But sometimes when we work on these cases, we would wish there were some horizontal overlaps so that the authority could focus on analyze them, but not focus on analyze the conglomerate effect, which could be a very painstaking, time-consuming process, could be very lengthy. Because SMR is quite sympathetic with conglomerate effect concerns, the Chinese stakeholders often take these concerns up to SMR, even if without any substantiated evidence, but just raise it as a very high-level concern. But because stakeholders are raising this, SMR would have to take that into consideration during the review. So what SMR is doing is trying to take this as issue and get both parties, on the one hand, the Chinese stakeholders, and on the other hand, the notifying parties to get into the middle ground. Actually, this is being taken as a very convenient tool by Chinese stakeholders when they are trying to achieve some non-merger specific commercial goals, or they are just simply trying to disturb the review process to make notifying parties' life a little bit more difficult. In the past 10 years, conglomerate effect theory of harm was raised in 7 cases out of the 40 intervention decisions, including 38 conditional approvals and 2 prohibitions, accounting for around 17% of the cases. And in recent cases, any possible potential conglomerate effect concerns were routinely heavily scrutinized by SMR, which makes quite some supposedly non-brainer cases more complicated. So in order to address conglomerate effect theory of harm, SMR normally would ask parties to commit to no tying, no bundling, post-transaction. And this is one example of behavior remedies SMR has been very preferred to use. As you can see on the left-hand side of the table, among the 38 unconditional approvals, there have been 21 cases where pure behavior remedies were imposed, not accounting into the hybrid remedies. Hybrid remedies were 10. This number is totally disproportionate to the type of theory harms. In the 38 cases, as you can see on your right, pure horizontal cases were 22. So normally you would expect to see more structural remedies to address horizontal cases, theory of harms, concerns, possible theory of harm in horizontal cases, but that is not the reality in China. And examples of behavior remedies include specific supply terms with Chinese customers, post-transaction, price guarantees, friend access to intellectual property rights, technology, no bundling, and last but not the least, whole separate order. So this kind of whole separate order is not a temporary traditional whole separate order you would expect to see within a divestiture process. It is long-term whole separate order, which requires the companies not to integrate, not to achieve any synergies post-closing for a certain period of time. So the certain period of time could be 1 to 3 years, but do not think you would be able to integrate after 1 to 3 years, because it would take another period of time to apply for releasing this whole separate order. So in reality, the quickest case where the whole separate order was lifted was after the deal, was 3.5 years after the deal was closed. So imagine the company could not get any synergies after transaction. At the same time, they have to bear the cost and the burden of complying with a very strict whole separate order. And the trustee, because they are not experienced with this kind of long-term separate hold separate orders, they would have to spend more time and cause more cost, and they could well take some quite intrusive measures in the daily life of the business. So not only the whole separate order could take quite a long time to get lifted or modified, but also the other behavioral remedies. So there have been 7 cases among the 38 unconditional approvals where the remedies have been modified or lifted. It is very difficult to petition for any change of the remedies conditions because SMR has a full discretion. They can take whatever long time they want to review the application for modification. So take a look at the true statistics. Among the 7 cases, 6 of them took 7 to 29 months to get their application approved by SMR, MOFCOM, after a full decision was made based on a very full competitive reassessment. So, as mentioned earlier, one very special aspect of the Chinese merger control review process is the third party, the Chinese stakeholders consultation process. Some would argue it is similar to market test, but it is different in the sense that it not only happening in the cases where you have a proposed remedy, it happens in every single normal procedure case. SMR has obligation to send questionnaires or to call the Chinese stakeholders to ask for their opinions on the transaction. The stakeholders can raise any opinions they have, including the non-antitrust related, non-merger specific. Imagine some Chinese customers might have some commercial disputes with you in the past, and they wanted to use this chance to get their goal fulfilled, so they would raise their concerns. You could also say it's probably similar to third-party complainants during the review process in other jurisdictions. It is still different in China in the sense that it is very opaque, not transparent. You have no access to file at all. SMR would not tell you who complained about what in what time period. You would have to do a lot of guesswork to understand what are the issues that are suspending your review. A lot of gamesmanship could be involved in the process, but unfortunately, we do not have very independent and impartial antitrust authority who can help to screen and check. I cannot blame SMR for that because SMR as an administrative body in China, in the rank, it is a little bit lower level than other ministries. It is lower level after integration than the predecessor MOFCOM or NDRC. So, for example, if your case in a ministry of in the area of agriculture, so SMR would have to consult with Ministry of Agriculture. Ministry of Agriculture is higher level in the rank than SMR. SMR has to wait for Ministry of Agriculture to give their concerns, which could be very likely industry-related considerations, not antitrust-related at all. But SMR has obligation to deal with it and to be the middleman to negotiate between all the multi-parties in order to reach a decision in the end. And a little bit unfortunate because of the current political environment, which is quite conservative in China, SMR, in our experience, seems to be more differential than before to the third-party stakeholders. So how to deal with it? We would advise clients to really identify all the potential Chinese stakeholders at the very early stage, at the very beginning, including Chinese customers, Chinese suppliers, Chinese competitors. And then we craft a message to do customer outreach to see whether we can detect any concerns beforehand. If that is not successful, at least we have the communication channel set up So in the end, if we could only hear from SAMR but not the stakeholders what their concerns are, we at least can try to have a side conversation with stakeholders to negotiate a deal. Probably the deal could be negotiated on the sideline so that it's not involved in the decision itself, so that you do not have to bear the compliance cost because you have a conditional approval. You can have unconditional approval, but you just have a deal with your stakeholders on the side. It's a very complicated process. It's not only SMR review process at all. So multiple parties are involved. You have to manage all the decision makers at the same time. Then speaking about the review timeline, it's quite a complex picture. It is indeed very true that since 2014, the simplified procedure was introduced. There were more and more simplified procedure cases over time, and the average review time for simplified procedure cases were decreasing. They are largely approved within 30 days after the case was accepted. I have to say, at the same time, we feel it is more difficult to get the companies get their cases qualified for simplified procedure. The case handlers are very conservative and very careful nowadays. They would ask you to provide any plausible data cut on any plausible market segmentation so that they can make sure you are definitely qualifying for the market share-based simplified procedure case criteria. That makes pre-notification phase much longer, although you would still have 30-day review period as a general guarantee for simplified procedure case, but that period only starts after your case was accepted. And also, there have been more than 50 cases where the review period was longer than 30 days. The longest one, if I can get the number, is more than 250 days. So if you really have a borderline case which you are not quite sure about whether it qualifies for simplified procedure, you might want to think twice, not least because there is another possibility where SMR might change their mind 2 days before your simplified procedure 30-day review period expires and let you know you actually should pull and refile as a normal case. So that takes your timeline even much longer than you would have get if you had filed it as a normal case. And also third-party complainants might come to SMR for them to pull your case off the simplified procedure track. And look at the conditional clearances. It is not getting much shorter at all. As you can see on the chart on your right-hand side, in 2018, the longest one is well beyond 450 days. You might ask, the longest review time period under the statute should be 180. How can we get to more than 450 days? So first of all, the phase 1, 30 days, phase 2, 90 days, and phase 3, 60 days only start after the case is accepted. So the time for the pre-notification period is not taken into account at all. And then second, you actually have a pull and refile system in reality. So after the 180 days lapse, and if your case is still being reviewed by SAMR would normally ask you pull and refile. I haven't seen any client refusing to do that unless they decided to abandon the transaction. So everyone would do that. Otherwise, SMR has no choice but prohibit your transaction. You pull and refile, the review day would restart from day 1. So you have another 180 days to go through. And there have been cases who refiled twice, so the timeline could be very long. There is no certainty as in the EU where you would have the statutory review timetable, or as in the US, you have a great timing agreement. So in China's timeline, it's really a little bit unpredictable. That being said, is China always the last jurisdiction to clear a global transaction? The truth is not, as you can see from the chart. US actually is, for all these cases I listed, I believe 11 of them out of 38 jurisdictions, out of the 38 unconditional approvals, where China was not the last jurisdiction to clear, U.S. was the last jurisdiction to clear. But I have to say that was mainly because in all these cases except 2, U.S. required upfront buyer, which required, of course, more time. But in China, they didn't require upfront buyer in these cases, so they can approve the main transaction first, but they would have to take another review period to approve the buyer. But even with that, you can still get your main transaction closed. So it's still not too bad result. I would skip these 2 slides, which I briefly mentioned already. And then I wanted to touch base on the topic of failure to file enforcement. This has been the SMR's priority in the recent years. There have been 28 cases where failure to file was sanctioned. MOFCOM normally detect failure to file by receiving third-party complaint or by reviewing your filings in the later transactions. So in Chinese filing, you would have to report in the past 3 to 5 years whether you have made any transaction in the same business area. And if you report a transaction that was not notified, MOFCOM would ask you whether you actually met the thresholds at the time. And this is a detection tool for MOFCOM SMR to find out whether you had failure to notify. And you can see on the chart on your right-hand side, most of the cases involved a joint venture. In China, there is no concept of non-full function joint venture, so any joint venture would have to be notified to the Chinese antitrust authority. And also, minority share purchase is also a little bit tricky because the concept of control and decisive influence under the Chinese rules are not that clear, and there is no such detailed guidance in the EU in China. So you would have to take some decision or think about your tolerance for the risk to decide whether you want to file if you have purchase of minority shareholding. And the lowest minority purchase that was sanctioned for failure to notify is 35%. Just as reference point. And MOFCOM SMR has also been very focused on multi-step transactions. So if you design the transaction at multi-step, in order to avoid a filing, you have to double check the Chinese rule to see whether you actually should have filed as a first step. And another priority for SMR in the recent years is to expand international cooperation. There have been a lot of cooperation between DOJ, FTC, European Commission, and China in the past cases. And there has been more cooperation with Russia and South Africa. With MOU signed with Brazil in 2017, I believe the more cooperation on specific cases with CADE will be on increase as well. Speaking of international cooperation, one area that SMR MOFCOM has been making efforts in the past years is cooperation in remedy design and remedy implementation. I wanted to just show one example of the international cooperation in conditional approval as the last topic of my presentation. So in Abu Syndrome medical case, we actually see very good cooperation between the authorities. In this case, MOFCOM approved the case, the main transaction, and the buyer at the same time, 6 months after filing. It is one of the quickest conditional approval by MOFCOM. It's a fix-it-first remedy case, but fix-it-first is more like the EU fix-it-first type. Is not like the US. The terminology in China is similar to the terminology in the EU, which means you would have to approve the main transaction and buyer at the same time as the same decision. So the buyer identity was informed to MOFCOM very early on, probably in phase 1. And briefing paper on the buyer on the remedy was discussed with MOFCOM very early, even if it was not officially finalized with European Commission or with the U.S. authority, with FTC. So MOFCOM was very well in the loop and very well informed. And in the end, the result was very good. So the main transactions, the buyer were approved at the same time. And there was no concern about whether the same buyer would be approved by SMR after your main transaction was approved. It's a very good result. However, I would not say that this is a good approach for every case. For some cases, you might want to have less intervention or involvement of Chinese authority in selecting buyer, especially if there are Chinese potential buyers. So different approach might need to be applied in different cases, different scenarios. Thank you.
Obrigada, Cunzhen, pela excelente explicação sobre o direito antitrust chinês. Eu passo a palavra para o meu colega Rick Rule, sócio da área antitrust do escritório Paul Weiss, baseado em Washington. Rick.
Thank you, Joyce. Thank you. Let's see if we can. Here we go. Thank you, Joyce. I want to also thank IBROC for inviting us and look forward to sharing ideas with you all. The deck that I put together, which hopefully you'll have access to at some point, is lengthy. I'm not going to try to go through all of it, but a lot of it is there as background information for you to the extent you're interested in diving into some of these points. First, I want to talk, just give you an idea of who the Department of Justice and the Federal Trade Commission are. They're two organizations in the United States, unlike even in China, when there were three organizations. They have duplicative jurisdiction. They both can look at mergers. And as I'll explain, there is a clearance agreement that's an informal agreement that the two agencies have that makes sure that only one agency is investigating any merger. The Department of Justice, it's the Antitrust Division of the Department of Justice. It's led by Macon Delrahim now. He's the Assistant Attorney General. It's a job that I had a while ago. Judge Ginsburg, who's here, also had it. They are presidential appointees, get confirmed by the Senate. The other people on this page are what we refer to as the front office. They're the people who help make the decisions. They're all political appointees in the sense that Macon chooses them and they sort of serve at his pleasure. The person who's most relevant on this chart is probably Barry Nigro, who is the Deputy Assistant Attorney General who deals with mergers. The Federal Trade Commission, on the other hand, was formed a little bit later. It doesn't have the authority to use criminal process, so it tends not to look at cartel matters, but it does look at mergers. It's a commission with 5 commissioners. 3 are the president's party, 2 not the president's party. We had a somewhat unusual situation when President Trump was elected in that he was able to fill all of the positions on the commission. It took a while, but as of last fall, here over on the left are the 5 commissioners. On the right, there is a structure that reports up. The part of the commission that looks at mergers principally is the Bureau of Competition, headed by Bruce Hoffman, who is selected by the chairman. The Bureau of Economics, which supports both the Bureau of Competition and the Bureau of Consumer Protection, is Bruce Kobayashi. And the director of the Bureau of Consumer Protection, which is for privacy and those sorts of matters are housed, is Andrew Smith. I'm not going to. This is where we get into the eye chart portions of the deck. But I just put this background here because it's important to keep in mind that the U.S. in some ways is kind of a unique jurisdiction for looking at merger and doing merger control. We have had merger enforcement really technically since the beginning of the Sherman Act, certainly with the enactment of the Clayton Act in 1914. But the Clayton Act, Section 7, was amended in 1950, and that has been the source of the law. In the United States, it's still the case, was the case then, mergers are lawful unless the government can go in and prove to a court that the merger would substantially lessen competition or tend to substantially lessen competition or create a monopoly in some market. A lot of the case law that is still important was created before there was any pre-merger notification. And the other thing that I think is worth noting, the Clayton Act can be enforced not just by the Department of Justice and the FTC, but also by state attorneys general. We have 50 states, and each has its own attorney general. They can sue. And interestingly, private parties, if they have standing, if they have would suffer antitrust injury, can bring a case. It was in 1976 that the U.S. first introduced merger filings and a suspensive regime. The idea was to look at, to get notice of mergers, get tools for investigating them before there was a scrambling of the eggs, as we would say in the United States. So it set up a regime. Hart-Scott-Rodino, our firm and others deal with your firms a lot of times. And a lot of times the discussion has to do with the regulations for whether or not you have to file. And what's interesting about those in the United States, and I think somewhat different than others, is there's actually not a lot of relationship between the HSR regulations and when you have to file and the substantive law. The way the regulations were set up, interestingly, was to protect the agencies from a deluge of filings. They were concerned about having too many and being overwhelmed, so they wanted to set up rules that would, in effect, allow them to triage and only see those deals that might be a problem. And so there are a lot of rules about when you have to file and when you don't have to file. Also, the interesting thing about this is the filings in the United States, as some of you may know, are very simple. You provide certain description of the transaction, certain revenue data, and you provide documents that are looked at by the board or the officers and directors that analyze things about the deal, like market shares and that sort of thing. But that's it in the filing. There's no interaction with the staff to draft the filing or anything else. You make it. It's fairly simple. A lot of times in deals, it gets filed way before any other filing. But part of the reason for that is that, as I'll show in a minute, the vast majority of HSR filings are resolved in the first filing, are really not of concern to the agencies. And as we'll discuss, a much smaller percentage actually get a thorough investigation. But this initial process is 30 days. If there might be an issue that could be resolved without an extensive investigation, you can pull and refile, and this first period can take 60 days. But it's very simple. It's very easy to do. You don't have to interact with the staff before you make a filing. If, however, after that 30 days or 60, if you've pulled and refiled, there's an issue, that's when the real work begins. And again, if you keep in mind that in the United States, the Hart-Scott-Rodino process is designed to help the Department of Justice or the FTC investigate a transaction to make a decision whether to go into court to try to stop it, you can understand a little better how the process works. It really is an investigative tool, the second request. It requests pretty much all the documents of the company, a whole raft of data, a lot of interrogatory questions, and it gets a lot of information to the staff, but they're also using that time to investigate, to talk to third parties, to actually do depositions because they can send CIDs to do that, and then the whole point of the process is that after the parties substantially comply, they have 30 days under the statute to make a decision whether to go into court. And after 30 days under the statute, the parties are free to close their transaction. As a practical matter, because parties don't really want to go to court, because of the uncertainty of a court proceeding, because of the time of a court proceeding, that does give the government a fair amount of leverage, and it's that leverage that they use to get remedies, to get fixes, as we call them, whether they're structural, and they tend to be structural, or behavioral. But they also find their way into court orders or FTC orders that can be enforced if people don't live up to what they've agreed to do. In the case of DOJ, it actually gets filed with a court. The court has to enter it. There's a process called the Tunney Act that you go through. So it's a much more formal process if they challenge it. Even if they get a remedy, they still will file in court. That then, and I think, as you guys deal with U.S. enforcers, you should think about the unique aspects and customs in the process. First, as I said, it's a much more backloaded process. It's easy to get on file. Most of the work happens in that small percentage where there's a second request and they get a lot of documents. That's when you file white papers. That's when you go in and meet with the staff. That's when you go to the Assistant Attorney General or the Commission who makes the decision. It's also important to realize that the Department of Justice and FTC have powers beyond the Hart-Scott-Rodino Act to investigate transactions. So they use CIDs to get depositions. Sometimes they'll send additional CIDs for documents to the parties. They'll sometimes send CIDs, which are compulsory process. Folks have to adhere to them, to third parties to get information, and sometimes even depose third parties to get information. As representatives of the parties, you don't have an opportunity to see any of that information unless and until your client gets sued in court, and then through civil process you can see that. So you generally never know what is being said about your transaction or who is saying it. You can sometimes try to figure that out based on the questions you get, but it's a somewhat opaque process, again, because it's an investigative process. Second thing to keep in mind is the second request process, even though the statute says you get a second request, you respond to it, then the clock begins to run for another 30 days. There's a great deal of flexibility in the process today. The second request period and how long the government has to investigate or to go into court is in almost all cases today superseded by a private agreement between the parties and the department or the FTC. And so unlike the EU process, I think your process, there's much more flexibility in terms of how long the process goes, how much information they get, and that sort of thing, than is true in other jurisdictions. That's a good thing in many cases, but it also can create some of the issues that Cunzhen talked about in terms of why it takes so long sometimes for the U.S. process. And I'll give you some statistics on how that's grown over time in the next slide. if you can see, in 2014, the average second request investigation took 7.7 months. It got up to 10.8 months in 2017. It's down to 10.2 in the first half of this year. But that's the average. And sometimes they can take 18 months or longer. And again, if you look at the progression of timing agreements, over the last 3 or 4 years, the time period the government was asking for after you had provided all the information had grown progressively longer. Macon Delrahim has indicated that he wants to change that and try to resolve second requests within 6 months. We'll see whether or not that is accomplished. I can say we were involved in the Cigna transaction, which was a big deal in the United States. It's about a $60 billion deal, but it was really largely limited to the United States. And I think in part because of the department's interest in getting deals done quickly, it was resolved within 6 months. I'm not going to spend too much time right now on international cooperation and procedures, but before I came here, I asked Barry Nigro if there was anything that the department would like to convey to an international audience, and he did say that the one issue that they are seeing in terms of coordination is coordination on remedies. And the fact that parties sometimes today will go and cut a deal, for example, with the EU, that involve the selling of one set of assets in an overlap situation before they've worked the matter out with the Department of Justice, when the Department of Justice wants the other set of overlapping assets to be sold. And he pointed out that if you don't coordinate that, you can have a real problem because you may have formal undertakings with another jurisdiction and the United States may say that's not going to work for us. You're going to have to sell the other assets. And then the parties are in a bind. They either sell all of the assets or they have to go back to the original jurisdiction and modify the undertakings. And so it's important as you go through these jurisdictions to keep in mind that at least the Department of Justice, I think the same thing is true of the EU, and the major jurisdictions are not going to take a position that if they think one thing ought to be done that seems to be mutually exclusive with something another agency has done, they're not going to defer to the other agency. They're going to pursue what they think is necessary, even if that puts the parties in a bind. So that's why you need to coordinate. I'm going to quickly go through some recent enforcement activities. This one is a chart that basically shows the number of second requests in the United States since 2014. What I think is important about this is not so much the absolute number, but the percent. So as you can see, 3.2% was the largest percentage of filings that were made that got second requests in 2014, but it's always hovered around 3%. So that gives you an idea that there are a lot more filings that are made than are actually really focused on in the United States. This slide, which I'm not going to spend too much time on, gives you an idea of what happens and what has happened in significant U.S. merger investigation outcomes. And the bottom, it shows that many deals are abandoned, and some of those after complaints. But the vast majority, which is the green bar, are still settled and probably always will be through consent decrees. I'm going to just again quickly go through horizontal transactions. I'm not going to talk about all of these. But if you look at the period really until about 2010, from maybe 2004, 2005, the agencies actually litigated very few cases. They actually filed on very few. Parties knew that. Some of the deals the Department of Justice got were criticized because they were pretty weak. But that started to change in 2011 with AT&T T-Mobile. The government went in, was successful in blocking. You can see some of the others. They didn't always block all of these on the page. For example, U.S. Airways American was settled with a consent decree. But in all of these cases, the agencies have kind of figured out the best way to go into court and persuade a court to block a merger. And the reason that they had been so quiet in that previous period was because they lost in a case called Oracle PeopleSoft, in a case they thought was a laydown winner, a 3-2 transaction, but they still lost. What they found out is that courts in the United States tend to look at mergers differently from the experts. They tend not to be so focused on concentration ratios and that sort of thing. They really do need to be told a story as to why this is going to harm competition. And the story that the government has sort of developed and the way they go is by focusing on the documents, telling the story that the parties expect to harm competition, and finding that one of the parties is a maverick and would be, its loss in the merger would harm competition. And that's been sort of a successful approach that they've taken in all these mergers. I'm running out of time, so I'm not going to spend a lot on this. The one that I think is interesting on this list of recent activities by this administration is Bayer Monsanto and Dow DuPont. The reason that Monsanto Bayer, we were involved for Monsanto, and I'm sure it's very familiar here, is that was a deal where actually R&D competition was important, probably more so even than Dow DuPont. And there was only one company who could fix the transaction. And the government has said that. So unlike most decrees where there's a possibility of a backup buyer, in the Monsanto Bayer case, if the divestiture to BASF doesn't work out, there's no other alternative. That is the reason that DOJ gives for why it took so long. Before closing, the one thing that you will see in this deck, two other discussions, the vertical merger enforcement and some other recent issues. Vertical merger enforcement is unique because for years nobody thought the U.S. government cared about vertical mergers. Then we brought the AT&T Time Warner case. The government is still litigating that issue. The two things there are the importance of bargaining theory, which is very important in U.S. Antitrust, and the notion that the appeal is interesting because the government is saying the court failed to take into account economic principles and relied too much on the evidence, which is an interesting concept from our perspective. However, I think these two recent transactions, these two pharmacy health insurer mergers or PBM mergers, suggest that the government's not really that concerned about vertical mergers. There were vertical issues there, but in both cases, the government cleared them without problems. I will stop there, but I'm happy to answer any other questions about some of the other developments in the United States.
Obrigada, Rick. Eu já passo a palavra para o John Boyce. Ele é sócio de antitrust do escritório Slaughter and May e fica baseado em Bruxelas.
Obrigado. Boa tarde a todos. I'm also very grateful for the opportunity to be here in Campos, so thank you to Ibrahim for that. But now it's my job to take you back across the Atlantic to where I've come from, Brussels, to talk about some of the hot topics there. I've got some headlines on the slides. Basically, what I want to do is take you through some statistics. I then thought I'd focus on two particular issues. One is gun jumping risks. I think that's also an interesting topic for people in Brazil. I see nodding of heads, which is good. And Also, I want to have a look at some of the risks that people face if you provide misleading information to any of the competition authorities, but it's a bit of a hot topic in Europe at the moment as well. So, starting with some statistics, my next slide shows a couple of trends. They look quite visible if I tell you what they are. The upward pointing line is looking at the number of cases that are being dealt with in Brussels by the European Commission under Europe's simplified procedure. So you'll see that in actual numbers, it's been going up for a little bit more than 150, 5 years or so ago, to, I predict, 300 cases under the simplified procedure this year. Currently, we're at 220 to the end of September, but if you extrapolate that forward, I think we'll be hitting 300 cases handled under the simplified procedure. That's a relatively straightforward process. If you meet those criteria, you can get the process through relatively quickly. You hear a lot of stories about how Europe takes a long time, but in most cases, it can be pretty straightforward. And then interestingly, if you look at the cases which are not handled under the simplified procedure, it's a flat line, about 100 cases a year for the last 5 years. Even this year, which is seen to be a particularly busy one, and I think September was the busiest month on record for the European Commission in terms of new merger notifications, but we'll still only have about 100 cases being looked at under the what used to be called the normal procedure. The normal procedure is now effectively the simplified procedure. You'll see that even 5 years ago, it was about 61% of cases, but so far this year, 78% of cases have been handled under the simplified procedure. The next slide sort of zooms in a bit on what that means for phase one outcomes over the last, I've gone into the last 3 years. So just looking at the year to date, September, as I say, 220 cases under the simplified procedure, 41 cases cleared unconditionally at phase one so far. But that doesn't mean it's a walk in the park, those ones. Those can be very difficult cases, and some of them are cleared without conditions because the parties have spent many months in pre-notification to satisfy the Commission that there aren't issues that need a remedy. Then you have a small number of cases which are subject to phase one commitments, 8 so far this year, and then 8 where the Commission opened a full investigation, a phase 2 investigation. So this year, up to the end of September, 308, as I say, about 400. It could be that we hit the magic number of 402, which is the record ever achieved by the European Commission back before the financial crisis in 2007. I remember those days. We were all working very hard then, but I get the feeling we're working even harder now. The next slide shows the phase 2 cases, the outcomes of phase 2 investigations over the last 2 or 3 years. There's no clear pattern, but that's just because we're not looking at a large number of cases, so it really depends on what the cases are. What's interesting, if you look at the 23, I think it is, cases which are covered by the slide, a lot of them are cases which have got no impact at all outside Europe, so they're essentially looked at by the European Commission. But some of the techniques that are being applied in those cases, I think CAGE is learning about them. So the fact that it's purely a European case doesn't mean that CAGE or you as competition lawyers shouldn't be interested in them. If you look at the prohibitions, there have only been 3 prohibitions in that period. Those fall into that category. They're not cases that CAGE or even the DOJ or FTC would have looked at. There was the Hutchison 3G Telefonica case, which was prohibited in 2016 to do with mobile telecoms in the UK. Talking about mobile telecoms, it's an area where there's been a lot of concentration within Europe. So there's also on the slide Liberty Global, which is a Dutch case, Liberty Global Base, and Hutchison Wind, which is in Italy. Those cases were cleared subject to conditions. The other 2 prohibitions in 2017, one Heidelberg Schwenk Cemex, probably you haven't heard of it, but the clue's in the name, Cemex. It was another cement case, but the market was essentially Croatia. Deutsche Börse, London Stock Exchange, well, that speaks for itself. That was another prohibition, but very much focused on issues in Europe. I'm not sure if it's even notified anywhere outside Europe. But you do see on the slide a number of familiar cases, which would have been looked at by CADE as well. Some of them were on Cunzhen's slides, and some on Rick's slides. Back in 2016, you had the Bull-Rexon case, which I know CADE spent a lot of time on. We've got the Dow DuPont, ChemChina, Syngenta, which were conditional clearances, and Bayer-Monsanto, of course. Praxia Linda, which we've heard a bit about already on this panel and elsewhere. And then the Siemens Alstom case, which is down at the bottom, because that's one that's work in progress. But I think that's been looked at by CADE as well. Yeah. What do the stats show? They basically show, as I see it, that the Commission is trying to focus more of its resources on the more difficult cases. It's allowing cases which don't raise issues through more of them under the simplified procedure. I've actually found the Commission a bit more open to giving you the benefit of the doubt and saying we won't go in and look narrowly at a particular market here, which could have allowed us to say that the market share is above 20%, or deciding not to explore some of the more innovative theories of harm in a particular case because they know instinctively that it's not a problem case. But for the more significant cases, the resources they've got, they're focusing in on those, and we're dealing on those cases. We can feel the extra pressure by having more resources, big case teams on them. And I think it's fair to say that these additional pressures and challenges are in many ways a reflection of the modern world that we live in. It's very different from the world that I first knew of competition law 30 years ago, when really if you wanted to understand a market, you had to even go to the library and do some research about what this particular industry involves. I think one of my earlier cases was to do with gas boilers, and it was took me a lot of research and reading trade magazines to educate myself, and then find information that was relevant, and then put it into submissions to the competition authority, who would know very little because they didn't have the information either. Nowadays, it's all out there on the internet. Anyone can find it. And it's more the opposite that you have to do, distill the information that's out there and come up with what is really relevant. I mean, sometimes you'll find a case team will start doing its own research and come up with ideas which are might look well informed by something they read elsewhere, but then you have to put it to your client and they say, oh no, they don't understand the picture. But a lot more time is spent on trying to cut down the amount of data rather than sifting what's relevant. But despite the fact that we're trying to cut down the amount of data to make it manageable, CADE, the European Commission, they're hungry for that information. They're looking for it from different sources. Internal documents, that's one area which is a real source of interest for the competition authorities. We also like to find internal documents because when they might be looking for smoking guns, you can sometimes find the silver bullet in there, which helps you convince the Commission that some of the documents which look bad aren't really that bad because you can see the real story is here. But then there's the suspicion that all the documents are being created. So there's a great preference for pre-existing documents rather than things that might have been put together while the deal is being put together. We've touched a lot on one of the other pressures of the increasing globalization, as Joyce was saying. 120 jurisdictions. Thank goodness I don't think anyone's had to notify in that many jurisdictions so far. But when I started out, the only mandatory filings were basically the US and Germany. And then you had a number of voluntary regimes like the UK and France. It's a very different world now. We're also under increasing cost pressures and time pressures from clients, commercial pressures on them because they've got activist investors who are out there wanting to see deals being done. We, I think, are all now around the world familiar with concepts like break fees that put even more pressure on you to get the deal done, and you sometimes wish they weren't there because the authorities know that if you don't get the deal through at phase one, then you could face a break fee. and therefore you're under pressure to get deals done when you might actually be able to convince the Commission if you had the luxury of more time. I've also flagged on the slide the increasing role and influence of third parties. Third parties, in Europe, and I guess it's the same in Brazil, some of them are very keen to participate. They've got their own agendas as to why they want to put their arguments to the Commission, but there are also others who become the victim of the appetite that the authorities have for more information. These third-party RFIs in Europe, they tend to be online forms with very tight deadlines, and some parties are very cooperative, and others do wonder why on earth they have to spend their time fitting in these forms. In the US, I think it's much more common for the regulator to pick up the phone and speak to people, get information that way, and ideally that's where the European Commission would be, but we do also face language barriers which make that somewhat more difficult in Europe. And I think another reason why we're spending more time on cases than we used to is that although concepts like horizontal and vertical mergers are pretty clear, the European Commission at times feels like a sort of hotbed for development of new theories of harm. There's a lot of concerns and agonizing about how you deal with big tech, big data companies, where I think really the gut feeling is one of there must be something wrong with this because we're not sure where the world's moving, and if we don't do something now, we could let through somebody who'll become a dominant player in 3-4 years. So we need to investigate now to understand what's going on. The Dow DuPont case is, a lot of people have spent a lot of time on the conference circuit talking about some of the innovation theory of harm that's been developed in that case. I mean, again, I see that as a case where the agencies feel, well, we're not sure where the market is going, but it could get a lot worse because it might be that the new pipeline of products which is coming up will be the blockbuster in the future. So we need to investigate now and be concerned about innovation rather than waiting to see how the market develops. So just to sort of sum it up, I think we live in times where we're data rich and time poor, and that gives us challenges on both sides of the table. I sometimes like to think that we and the regulators are actually on the same side of the table. We are here, but what we're trying to do is make sure that we can understand the facts, see what the challenges are created by a particular merger, and try to work to convince you that the way in which the market is developing is that you shouldn't have those concerns. So we're all on the side of justice and getting the right answer. We don't necessarily agree with each other on the answers that we each come to. Moving on, my next slide is a tweet from Commissioner Vestager. I'll read it in full. She sent this in the morning of the 6th of July, 2017, not at 2:32, which is what it says, but that was the time in New York. She sent it about 8:30 in the morning. And it read, 3 statements of objections in 3 separate cases. Not giving full accurate information or putting a merger into effect before cleared. Don't. So, what was she talking about? Well, first off, gun jumping. So she's saying, don't jump the gun. We, I think, have all faced this in cases, many cases, where there are concerns that the client's got about contacts that there are, concerns that the lawyers have about pre-closing discussions and cooperation that may go on between the parties before the deal is actually approved by the Commission or before the deal closes. There are all sorts of commercial and corporate pressures that we're under. You can sometimes get into discussions with your corporate partners and colleagues if they're the ones handling that side of the deal. I guess there are a number of deals that you're involved on in Brazil where the first you hear about it is you get a call for some lawyers in Europe or the US saying, this deal's been announced and we want you to notify. And you won't have been involved in all those aspects of the deal, but then there'll be the due diligence that's being done, where the purchaser is going in and getting lots of useful information about the target. Is that a problem? Or generally speaking, you need to understand what you're buying before you can place a proper value on the business. You'll have issues about once the deal is done, the target might have some great new ideas and wants to implement them, but then the purchaser will be concerned about we don't want them taking the business in a direction which is not the way we want to take it post-closing. So to what extent can the purchaser get involved? Integration planning, I think you'll be familiar with those sorts of issues. Sometimes you'll have the parties also looking at doing some joint collaboration before the deal is put together. What are the concerns there? Are there gun-jumping concerns about early implementation? Are there wider antitrust considerations? A lot of these issues can be dealt by confidentiality agreements, non-disclosure agreements, and clean teams. I very briefly want to talk about what was at the top of the slide, transactions with warehousing structures. These were very topical a few years back in Europe. I think they've really gone out of favor in Europe for various reasons, but where you have a seller of a business wanting to sell, A on the chart, wanting to sell to B, but there are competition issues there. You'll get we had a period when investment bankers were coming along saying, we'll help you out. We'll set up a vehicle company which you can sell to without needing a competition clearance. You, seller, get your cash, and we will then subsequently, for a fee, end up dealing with sitting through the process while B goes through the regulatory hurdles with regulators. In short, there was a bit of a loophole which was firmly closed, as I see it, by the Commission in when it amended the merger regulation in 2004 and issued a jurisdiction notice in 2007. So now, for the most part, we'd see doing step one on that chart would be seen as part of implementation of one concentration. So it's a partial implementation of the deal, which needs to be cleared. So we really don't see those anymore. I'm not sure if in Brazil you faced issues like that. About being the pressures of time, and for deals, I'm probably coming under pressure now, although I haven't had the 2-minute sign yet. So moving on very quickly to what does this mean in practice in Europe, looking first at gun jumping. Under the original merger regulation, the maximum fine for early implementation of a deal was only 50,000 euros, so nobody took it that seriously, or rather the Commission didn't take it that seriously because the resources involved in investigating these cases would have not been worth the fine at the end of it, but they would send out messages that it's very important that you file and would tick people off for not having notified on time. But that all changed with the 2004 amendments to the merger regulation. Now you can be fined up to 10% of worldwide turnover. There were a couple of cases where the fines of 20 million were imposed, and then last year, Altice was fined 124.5 million euros, not for putting the deal fully into effect, but for exercising influence over the target, the Portuguese telecom, before the deal had been cleared. I can see it coming. Yeah. And then one case that's in the pipeline is the Canon Toshiba Medical Systems case, where there are elements of our warehousing structure in there. That was one of the SOs that was sent back in July 2017, so the case is still pending. Canon had already been fined by MOFCOM, 40,000 euros, and criticised by the JFTC, so we wait to see what happens there. And then quickly looking at the warning, don't mislead. You must give full and accurate information in your notification and in responding to RFIs. When you complete the Form CO, the notification form in Europe, there's a declaration about you declare that everything that you put in is accurate to the best of your knowledge. Interesting development I've seen recently is that the Commission has started in RFIs. The last question tends to be, can you please confirm that all your responses above are complete and accurate? So you're really put on the spot. It focuses your mind on that. In terms of cases that the Commission's been running under the original merger regulation, again, very low fines, 50,000 euros, so not many cases. Then, May 2017, on the Facebook was fined 110 million euros for the Commission concluding that some of the information in the filing was inaccurate, and assurances that had been given that you couldn't match users' accounts between Facebook and WhatsApp, when it turned out subsequently that you could. There was an investigation and Facebook were fined. And then there are two other cases. There are two of the SOs that Vestager was referring to, Merck Sigma Aldrich and the GE LM Wind case, which are pending at the moment, so watch that space. That's really it from me. I just wanted to put up my headlines again, because if I had had more time, I might have talked about a couple of other changes ahead next year. On the 30th of March, the UK will no longer be part of the European Union, so we can, if anyone wants to ask me questions about that, I'm happy to take them. And also, we've got elections. Well, we've got elections in Brazil on Sunday. We've got the European elections, so over the 23rd to 26th of May. Nobody thinks a great deal about what that means for Europe, but there are some implications for the enforcement of competition policy, depending on who ends up being the competition commissioner. Obrigado.
Obrigada, John. Eu já passo a palavra para o conselheiro Paulo Burnier, conselheiro do Tribunal do CADE. Paulo, por favor.
Obrigado, Joyce. Boa tarde a todos. Em primeiro lugar, eu gostaria de agradecer o convite do IBRAC de uma maneira muito especial. Obrigado pela gentileza. Esse é um tema a mim muito caro, que eu já acompanho há alguns anos, e parabenizar na pessoa do Joyce mais uma edição do Congresso, da Conferência do IBRAC. O IBRAC é uma instituição elogiada em vários países mundo afora pelo trabalho que desenvolve, pela capacidade que tem de agregar juristas, economistas e outros especialistas da área de concorrência no âmbito de uma mesma organização, e fazem um trabalho muito importante aqui no Brasil. Então, parabéns por mais esse evento e obrigado pelo convite. Eu, da minha parte, onde é que está o... Vou tentar ser bastante breve, Joyce, e até para ter mais tempo para as perguntas, para um debate. E eu apresento aqui de uma maneira bem sucinta um roteiro para deixar claro o breve caminho aqui para ser percorrido, e tentando ter em mente a pergunta que a Joyce, a boa provocação que a Joyce fez do estado da arte. Então, tentar apresentar o estado da arte na perspectiva brasileira, desse assunto das fusões internacionais, em especial sobre o enfoque da cooperação internacional, que me parece ser talvez o maior desafio na perspectiva de um país, de uma autoridade da concorrência. Então, no primeiro momento, só apresentar alguns números desses 5 anos da nova lei do CADE. Então, de 2003 a 2007, os 5 anos cheios, levando em consideração que a lei entrou em vigor em maio de 2012, e nós estamos no final de 2018, compilados aí, portanto, os 5 anos cheios de alguns números, e em seguida contar um pouquinho como funciona a cooperação internacional na prática, que envolve basicamente dois vetores, um procedimento e outro de mérito. Depois trazer 2 casos como ilustração e tentar extrair desses 2 casos recentes algumas mensagens, até em diálogo com o que já foi dito pelos demais colegas, e encerrar. Claro que isso tudo eu me refiro à minha opinião pessoal, ainda que eu acho que seja bastante convergente com a opinião do colegiado, mas também trago esse disclaimer só para dizer que eu trago um pouco das minhas impressões. Em termos de números, eu acho que faço uso, peço autorização da Isabela Maiolino, que fez um estudo muito interessante. Isabela Maiolino, no âmbito de estudos de pós-graduação na Universidade de Brasília, na Faculdade de Direito da Universidade de Brasília, fez um levantamento muito interessante, que eu tomo a liberdade aqui de de citar como referência, que eu acho que dá uma ordem de grandeza do que vem acontecendo em matéria de cooperação internacional e fusões no Brasil. Lembrando, claro, que com a nova lei do CADE, passamos a compor, junto com outros países, outras autoridades da concorrência, o chamado controle prévio, pre-merger review. Então, esses números se referem a essa nova era do controle dos atos de concentração no Brasil. E a gente percebe que foram, grosso modo, 50 casos que foram submetidos à cooperação internacional nos últimos 5 anos, considerados 2013, nesse recorte 2013 a 2017, o que dá uma média aproximada de 10 casos por ano, facilitando a vida dos nossos amigos do MLEX. 50 casos e uma média aproximada de 10 casos por ano. E aqui, só para explicar como que o recorte foi feito, Isabela me corrige qualquer imprecisão, aqui foram considerados as cooperações internacionais acionadas nos atos de concentração ordinários, né? Chamamos de atos de concentração ordinários no Brasil, grosso modo, os non-fast track proceedings. Então, os procedimentos que não passam pelo formulário simplificado, que vão para o formulário normal, ordinário, e, portanto, desse conjunto de atos de concentração ordinário, aproximadamente 15% deles foram sujeitos a algum tipo de cooperação internacional, assim considerado um contato entre, pelo menos, uma outra jurisdição. Então, acho que esses números são números importantes porque eles dão aí uma fotografia de como tem sido esses últimos 5 anos. Nós temos, em média, 10 casos por ano que são submetidos a algum tipo de cooperação internacional. Me refiro especificamente a atos de concentração, a fusões. Um outro dado também interessante é o recorte de como essa cooperação tem sido feita com quais jurisdições. E aí a gente percebe um movimento, uma tendência, eu poderia chamar de tendência, de uma menor concentração com as jurisdições dos Estados Unidos e Europa. Esses números são consolidados dos 5 anos, então a gente percebe que 1/3 do número de cooperações acionadas, 1/3 delas é com a Europa, especificamente com Bruxelas, com a Comissão Europeia, 1/3 com os Estados Unidos, seja o FTC, seja o DOJ, e o outro 1/3 pulverizado entre diferentes países. Então, enquanto essa tela demonstra uma fotografia consolidada, o que a gente pode perceber ao enxergar os números em detalhes é uma certa tendência pegamos o ano passado, 2017, 2016, de uma menor concentração nos Estados Unidos e Europa e uma maior cooperação com outros países, e eu chamaria atenção em especial os países sul-americanos. A Argentina aprovou esse ano uma nova lei de defesa da concorrência e que passa a fazer parte dos países que adotam um sistema prévio de atos de concentração. Então, há aí uma expectativa de maior conversas com a Argentina e também países BRICS. Veja aqui o professor Alessandro Taviani, que era um grande entusiasta e incentivador do diálogo com outras autoridades, inclusive os países BRICS, e isso a gente consegue perceber. Um aumento do número de cooperações com outros países, digamos, fora do eixo Estados Unidos e Europa. Acho que é interessante também pontuar isso como um dado. Passando sobre como que a cooperação internacional toma forma na prática, acho que muitos, se não todos, a maioria pelo menos, tem experiência com isso, mas para desmistificar um pouquinho, que foi um pedido bastante legítimo que foi feito, basicamente a autoridade da concorrência entra em contato com outras autoridades da concorrência para tentar sincronizar procedimento e mérito. Então, na parte procedimental, é feito um primeiro contato para conversar sobre o cronograma, se já foi notificado em tal jurisdição, se há a previsão dessa notificação. É claro que isso passa por uma análise minimamente preliminar sobre potencial problema concorrencial. em outras palavras, um caso de fast track, um caso de ato sumário, ele não chega nessa tela, porque ele é aprovado no Brasil uma média de 15 dias. Portanto, ele dificilmente vai ser objeto do acionamento de uma cooperação internacional pela simples inexistência de problema concorrencial na perspectiva brasileira. Mas é feito um contato, em geral por telefone ou por e-mail, e que, então, sedimenta-se aí o primeiro contato, em geral entre os departamentos internacionais, para que haja uma mínima paisagem do cronograma nas jurisdições afetadas. E, em seguida, a parte mais importante, no sentido substancial, o mérito, que envolve vários aspectos. É interessante notar como que essa experiência de 5 anos no CADE revelou diferentes aspectos de mérito que são, sim, tratados pelas autoridades da concorrência, desde uma fase inicial da análise, em geral ainda na superintendência geral, mas que pode ser revisitada no tribunal, de definição do mercado relevante, de identificação de poder de mercado, até a fase mais avançada, que em geral é a que salta mais aos olhos, talvez por ser uma fase final, ou de fechamento mesmo da operação, que é a fase de remédios. Então, de fato, nesses 50 casos em que houve cooperação internacional, diversos deles experimentaram algum ingrediente dessa tela e, claro, talvez os mais expressivos, alguns deles já foram citados aqui por colegas do painel, Dow DuPont, Bayer Monsanto, tiveram uma cooperação bastante intensa na fase de identificação da solução. Portanto, uma vez o problema concorrencial ciblado, delimitado, qual seria a melhor forma de solucionar esse problema concorrencial, remédios estruturais, comportamentais ou híbridos, para usar o termo utilizado pela colega na apresentação dela. Então, isso um pouco faz parte do estado da arte, tanto os números como que acontece na prática. Lembrando que o principal objetivo, na perspectiva de uma autoridade da concorrência, em acionar a cooperação internacional, é evitar decisões contraditórias ou inconsistentes. Eu acho que essa é a principal meta, de trazer sinergia para as análises, e nesse sentido, eu acho que merece ser dito, na experiência que eu tenho no CADE, as empresas sempre foram bastante proativas, colaborativas, porque eu acho que nesse ponto há um interesse genuíno e aí podemos dizer, usando a expressão aqui do John, estamos do mesmo lado da mesa, nesse sentido de que há um interesse genuíno de colaboração para encontrar uma eventual solução para um problema identificado. E vemos aqui, o John, apesar de ter a bandeira da Bélgica, nós continuamos do mesmo lado da mesa, aqui fazendo alusão à Copa do Mundo, sem qualquer, não ficou qualquer ressentimento daquele jogo. Até porque metade do meu coração é francês, então eu me sinto muito à vontade de brincar com a bandeira belga do John. Mas vamos seguir, e aí, realmente, para caminhar para o final, Joyce, citar 2 casos a título de ilustração. De novo, ilustração do estado da arte desses 5 anos desse assunto no Brasil. Eu acho que o caso Bayer Monsanto é um caso bastante ilustrativo, é um caso recentíssimo, foi de meses atrás, é um caso de 2018, e um caso interessantíssimo na perspectiva brasileira, porque o Brasil surgiu como um principal mercado da operação. Portanto, havia um interesse da parte de outras autoridades da concorrência em acompanhar de perto como seria a análise do Brasil e eventuais remédios no espírito de evitar decisões contraditórias e inconsistentes. Então, realmente, nós vimos no Bayer Monsanto um interesse muito grande da parte de outros países, o que foi bastante positivo para a gente, porque era um caso denso, foi um caso difícil. 29 jurisdições foram notificadas, e é um caso que envolveu ativos no Brasil, os remédios foram sim conversados, esses dados já são todos públicos, inclusive a operação o desinvestimento, que foi a principal parte, né, do remédio, um remédio estrutural, com uma carga estrutural bastante forte, foi, de certa forma, sincronizado entre diferentes países afetados, me refiro especificamente ao Brasil, Europa e Estados Unidos, e também houve remédios comportamentais que tinham uma natureza complementar e acessória ao remédio principal, que era o desinvestimento. Portanto, a gente vê aí um mix híbrido de remédios comportamentais, estruturais e comportamentais, e uma conversa bastante intensa entre diferentes autoridades da concorrência do mundo, inclusive para fins de trustee, de monitoramento, uma fase de efetividade do remédio. Portanto, eu acho que é um exemplo bastante ilustrativo que, na minha perspectiva, é claro que eu sou um pouco bias, sou um pouco suspeito pelo fato de estar há tantos anos envolvido com o CADE, insere o Brasil definitivamente na esteira das Big Four, das jurisdições que merecem ser consultadas e precisam ser conversadas durante um processo de uma fusão internacional. Um outro caso também interessante, e esse eu cito a título de diálogo com o que o John trouxe de gun jumping, que é um assunto que eu vejo que na Europa realmente foi um pouco, voltou como um hot topic nos últimos anos. A gente teve, eu acho que um precedente importante de uma fusão internacional, em que, por acordo, as empresas aceitaram uma contribuição pecuniária de 30 milhões de reais, que é o mais alto valor das contribuições pecuniárias na história da nova lei do CADE. Então, a gente vê que, por conta do volume da transação, foi um caso de um impacto grande. E, no fundo, acho que esse caso tem uma mensagem muito, para ser bem objetivo, uma mensagem importante nesse tema de fusão internacional. Que as empresas trouxeram um argumento bastante legítimo de que seria um caso de um carve-out. Então, o Brasil e um outro país teriam sido desconectados ou congelados da operação, ou seja, não houve uma negação de que a operação foi implementada, pelo contrário, foi divulgada através de um press release, uma empresa americana e uma empresa francesa, e a alegação de que um carve-out, o argumento, bastante legítimo, né, sobretudo naquele momento, porque era o primeiro precedente, de que o carve-out seria elemento suficiente para excludente de licitude ou, como pedido subsidiário, como atenuante. Então, esse era o pedido do ponto de vista jurídico. Olha, o que aconteceu foi isso, e isso seria um caso de excludente de licitude ou de atenuante. E o CADE o tribunal, na ocasião, deu uma mensagem bastante clara, pelo menos assim espero que tenhamos tido o sucesso de ter passado essa mensagem, de que no Brasil, pelo menos, o argumento do carve-out não seria aceito como excludente de ilicitude, tampouco como mitigação da ilicitude. Foi o recado e foi até uma decisão consensual do tribunal nesse sentido. Eu acho que é a principal mensagem que se extrai desse precedente, Joyce. Então, realmente, para fechar, dizer que nos últimos 5 anos eu acho que foram bastante ricos em termos de cooperação internacional na esfera de fusões internacionais. Nós podemos afirmar hoje, por questões estatísticas, que aproximadamente 15% dos atos de concentração ordinário notificados ao CADE são submetidos a algum tipo de cooperação internacional, muitos deles fazendo uso do chamado waiver of confidentiality, do termo de renúncia à confidencialidade. E também, talvez, uma tendência, ainda que seja um pouco incipiente, a afirmar de maneira peremptória uma maior diversidade de jurisdições nas conversas que são entretidas. Realmente, para fechar, um dado de 2017, a gente levantei conjuntamente com a Isabela Maiolino, com base nos atos de concentração que foram sujeitos à cooperação internacional do ano passado, portanto, usando essa amostragem, uma amostragem que talvez merece ser expandida para ver se confirma, mas para o momento, os 12 casos que foram submetidos à cooperação internacional do ano passado, eles essa transação foi notificada em média a 10 jurisdições. Então, né, a gente está dizendo que em média, claro que o Bayer Monsanto entra na estatística de 2018, né, que são 29 jurisdições, então ela puxaria para cima essa média. Mas o ano passado teve Dal Dupont, que se não me engano foram 25 jurisdições, salvo engano. Puxa um pouquinho para cima, mas enfim, é uma grande transação, como pode acontecer, talvez uma por ano, 2 por ano, mas é interessante notar que, em média, as fusões internacionais do ano passado foram também submetidas a uma média de 10 jurisdições no mundo. Também tivemos a oportunidade de levantar a média, a título de curiosidade, de taxas de notificação, e houve uma média de 320 mil euros de taxa de notificação. Conversa também com um estudo que a Joyce trouxe da ABA, da PricewaterhouseCoopers, sob encomenda da ABA, e que também tentou fazer um pouco esse exercício, e a gente buscou fazer esse exercício na perspectiva brasileira. Lembrando que, da parte do CADE, os atos de concentração ordinária têm tido uma média de análise de 96 dias, portanto 3 meses. E aqui eu gostaria só de reforçar, para concluir, uma mensagem que foi deixada pelo superintendente-geral adjunto ontem, Kenneth Machado, que a Joyce também citou, no sentido de que as empresas podem, e de certa forma devem, vir ao CADE o quanto antes, né? Isso já aconteceu em alguns precedentes, inclusive um deles que foi citado, do Cescon Technical College. A gente percebeu, fazendo um quadro, um mapeamento de quando as operações foram notificadas nas diferentes jurisdições, que por vezes o Brasil é deixado por algumas semanas ou meses após. O que eu queria deixar claro na minha perspectiva de CADE é que o CADE tem tentado fazer a parte dele. 90 dias é um prazo bastante célere, inclusive comparado a outras jurisdições do mundo, para análise de um ato de concentração ordinário. Estou excluindo aqui os fast tracks. Portanto, quanto mais cedo, é claro que existe a fase de pre-merger notification, mas quanto mais cedo vier, mais fácil fica mais rápido, claro, fica o encaminhamento final. Era um pouco dos números que eu tinha em mente. Joyce, claro que eu fico à disposição para perguntas e comentários que eventualmente surjam. Obrigado.
Obrigada, Paulo. Bom, em razão aí do horário, eu queria ver se a gente tem alguma pergunta da plateia para finalizar o nosso painel. Tem alguma pergunta? Não? Bom, então podemos encerrar aí, porque a Leonor já chegou e dá uma bronca, então não volta aí, né? Então, encerrar, então tá bom. Obrigada aí a todos.
Exactly.
I really appreciate your presentation, so congratulations, and if you're interested...